and welcome to my channel. Today I would like to discuss what to expect when you come to my office and would like to have a consultation. I ask three questions, and sometimes of course more, but three major questions I decided to put in this channel. First question is, what do you expect from me and what I expect from you? Let's say you came to the consultation, we spoke for I don't know, like let's say an hour, and I described to you the law, what the judge would expect in this situation, or what actually would happen in my experience in your case. And then the question asks, what do you expect? And this is my filtering process, and sometimes people get very unreasonable where I have to go right in the core of the issues. Let's say, as you know, California is a non-fault state, so it doesn't matter who cheated, who did what. And then the husband and wife says, well, she or he cheated, therefore I want sole custody. And I don't care that the law says whatever, joint custody and no fault state. I want to go and I will pay you whatever, you just have to do it. Well, I'm not the type of lawyer who will do it. I will tell my client, look, if you want to do it, I probably not going to be the one. And I had to say it to a few clients, and it didn't work out. It was actually right in the first minute of phone consultation we had. They didn't care. They wanted to just do it. And I know, although I haven't done that, however, I know that after a while, once they not succeed and get the bill for my attorney's fees and potentially sanctions from the other side, they're not going to be happy. So I rather have them be not happy in the moment and do whatever. So that's the first thing that I like to figure out. I wrote these things out so I don't forget. And then another question I ask in the category of expectation is, actually I don't ask it, I say what I expect from my client. I'm a pretty responsive person, and I like to respond to my clients within one business day. Usually it's within a couple hours. It depends on where I am, if I'm in court or whether I'm with a client, if I'm on my computer. I pretty much respond between 3 to 4. And I had clients who would disappear for a week. And so at the beginning of our consultation, we align the frequency and responsiveness. It happened very rarely, but I prefer to keep communication, even if someone disappears and says, hey, I will be out of country for 3 months, just so you know. So I appreciate that type of courtesy. And then I also expect from my client to be reasonable. I know it sounds obvious, but some clients are so wrapped up and they forget why they hired me. They want to go their way, and some of them just like, okay, you're the lawyer, you just sign here, and this is my course of action. And if I know this course of action is a dead end, I will tell them that. And so when we first set up a consultation, I actually had to refuse one client who had millions of dollars in assets, but he didn't need a lawyer. He needed a marionette who would, meaning a person who would just follow his instructions and do whatever he says, even though it might be against the law or not ethical or even illegal, immoral, or whatever. So I refuse to represent clients like that. And the reason for that is I know at the end of the day they are not going to be happy. I won't feel as good as I could be as a lawyer and be helpful, and it's not a good working relationship. So expectations are the key. So that's the first, after a first consultation, that's the first course of action and questions we discuss. Second layer is preparation. I ask my clients to get ready for the divorce. Unless it's amicable and everything is on the table, usually 90% of the time, it's always a problem to get some documents. We have to start with document demand. I mean, unless the case again is amicable, where everyone is on the same page, no problem. They provide PDD, preliminary declaration of disclosure, meaning they provide all the packages, so we discuss, it's all perfect. But when I know the case is not going to be amicable, that's where we need all the documents. That's where I would say to my client, get as much as you can. If you have a joint account, go to your bank, print 3 years of bank statements. If you think he planned for this divorce and stopped working right before he filed it, well, get his records, his work records, get everything you can related to finances. So I'm sorry, my computer is going off. I didn't want to procrastinate this video anymore, so I did it on my computer. My apologies if the quality is not good or whatever. I just wanted to do it. Anyway, so and then in the preparation part, some clients are, in California or anywhere, lawyers are expensive, and some clients like to write their own declarations. They want to fill out their own forms. So I discuss with them the cost, and it will be kind of third part of this, but preparation is part of what I do. And then sometimes I ask if the client wants to write a declarations, and let's say if they file for joint custody, they file for spousal support, what are the facts, and they write it down, and they're happy to do that because they know they will save a lot of money. Some clients said, I don't care, just do it for me, please. I will tell you whatever you need to know, please do it for me. So then of course I do it for them, and either way I look it over and prepare, and it might take hours even though they write it, but still to get all the facts together from the clients is probably the best. Then I also discuss with the client how the communication is going to be. Is it going to be over the phone, via email? Usually it's always over email and phone. We meet the first time, and then the rest is all over emails. And also I ask them if they want me or if they want to communicate with their ex. Assuming there is no lawyer on the other side, I'm not allowed to communicate with the ex directly if there is an attorney on the other side. But let's say if there is no other lawyer, then I ask, would you like me to communicate to them directly? And then sometimes they would like to discuss things. If it's amicable, they don't need me. They just go and discuss their own things on their own, and they don't need me. And then one of the tricky questions I ask, what is the underlying reason for this divorce? And in my head, I think, it's none of your business. But nobody ever told me, Deanna, it's none of your business. All of my clients were really honest. In 7 years, nobody asked me that, but it's always something I'm thinking because I think it's pretty personal. The reason I'm asking this question, and I'm not asking that if it's amicable, I'm asking it if I know it's going to go not so amicable and the opposite, it's going to go crazy sometimes. If I know, for example, I had a couple clients, a man who came to my office and I asked that question, is like, yeah, I had an affair. And I can tell in their voice, they're so full of guilt and shame. And it's a clue for me. The clue is they're gonna be more vulnerable to give in to offers that are not reasonable. Let's say I'm just giving a very exaggerated example. Let's say the wife wants 90% of all of his salary, and for a couple of years, some crazy numbers or something that California law basically doesn't support. Then it's good for me to know. And in fact, I had clients who, it was a couple of years ago, one client, we were preparing for the hearing, and then she arrived. So that was when he found someone else, and she had a lot of houses that they're joint property, but it was in her name and it was still community property. Anyway, he, behind my back, and I'm not judging him for that because I know it happens, and sometimes it's a shortcut, and sometimes people don't care and they just want to move on. Anyway, he didn't consult with me. He signed off everything. And he sent me this 4 pages written document, and he said, Diana, please, I don't want to fight it. I just want her to have everything. And that happens. And it's good for me to know in advance, because when I know that in advance, I can prepare and maybe help to avoid that, ideally. But it happened one time where a client did that. Most of the time, when I know that fact, I say, okay, the underlying emotion is driving you to this result right now. Are you sure you want to make that conscious choice or not? And usually the client is pretty reasonable once I point out that's my belief is the underlying emotion driving to unfair agreement. And then final question is, or topic I discuss, is the cost. Every time. And it's perfectly fine. People ask the same question. How much is my divorce is going to cost? I don't know. The only way I can know if I'm fully in charge. For example, if they come to my office and 100% they know it's amicable. All they need me to do is to file for divorce, draft up a marital settlement agreement, file a final package, and they know that they're going to be responsive and they're going to sign everything, they're going to communicate. In that case, flat fee, $2,000 plus filing fees of $500, no problem. I'm in charge. I know you guys are going to respond pretty quickly. I know we get it done. Most of the cases it's not like that. I had cases they come to my office and they say, yeah, that's amicable. And then he hires a lawyer and the other lawyer starts to ask questions and we just go back and forth. So then it's not so clear-cut, amicable. Then the second version is where it's semi-amicable, but they have couple things they need to discuss, parenting plan, or they need to divide their pension via Quadrille and they don't quite know. I might have to do a video about the Quadrille, what it means. It's a qualified domestic relationship order where, anyway, I'm not going to go into it, but where it's not just a simple marital settlement agreement package be done, where there is some other work involved. I still do flat fee packages. It depends on the case, $3,000 to $5,000. Then if I know it's going to be a mess, meaning the other side is angry, it's not going to be amicable, it's going to be a court orders, we have to go potentially in trial. If I feel the storm, then I cannot give an estimate. I usually say if it's 1, 2, 3, 4 hearings, total timeline about 9 months, maybe 6 months, depending on how many assets and what, if the children are involved. But it's ranging between 3 to 8, 10, 15, sometimes 25. If it goes to trial, then it's a wild ocean. There is no. I had a case that was about $80,000 in attorney's fees. So it all depends. Anyway, so once we decide on the expectations and preparation on the fee, then I send my retainer agreement. The client reads it in advance. It's all structured about how the fee works. I send my invoices every week. And then once we sign, the retainer is paid. I put it in IOTA account, which is State Bar owned account that when I send my invoices every week, I charge it against the account. Once it's empty, the client is replenishing this account. So this is how first consultation works. And I also want you to introduce to my little monkey. She comes to my office, say hi every day. We work together. She's my assistant dog. Anyway, I hope you guys enjoyed the channel and I will talk to you soon. Please remember to subscribe if you would like to see more videos and like the video so I know I'm on the right track. Thank you.